On this side of the law, on that side of the law, who is right?
Well, hello everybody out there in podcast land. This is another edition of Law Talk, bringing common legal answers to common legal questions. I'm Mark the Attorney Judson.
Jonathan Law Dawg, Fontenot.
From the courtrooms of Calcasieu
To the marshes of Cameron Parish.
this is Law Talk. In Law Dawg, what's today's topic?
Powers of attorney.
Ooh, powers of attorney.
I have the power to be your attorney. That's what people hope it is. Gives you the power to be an attorney, but
What is a power of attorney?
power of attorney, I guess in common folk language, it's authority to sign on people's behalf, and you can conduct some business on their behalf. There are different kinds. There are general powers of attorney. There's some specific financial, real estate powered, medical powers. And you can actually, it's not forgery if you're signing your name for the person you have power of attorney for. Now, I've learned the hard way in a case I just had that doesn't give you the authority to go after they call it the mandate. That's the person whose power you've taken. You still have to give an accounting for those funds. You have to spend it at their discretion and for their benefit. You get power of attorney doesn't mean you get to go raid the funds.
So the agent, the
person with the power of attorney,
the agent. Yes. So the principal is the one who grants the power of attorney. The agent is the one who's acting on behalf of the principal. So the agent just can't go and clean out the bank account.
Some golden rules. Forget. Powers of attorney are for the living, wills are for the dead. As soon as the person passes, you still can't run around and do things.
The power of attorney dies with the principal.
Dies with the principal.
Okay.
And another rule is some people think they are some commandment by the court. They're not. They're not signed by a judge. They're just notarized. And some businesses recognize them and some don't. Some don't say they're toothless. You can go to the bank and say, "Give me all this," and the bank's like, "It's not our policy."
A third party doesn't have to recognize a power of attorney.
You don't insure, like, for example, you can't go pick up narcotic medication. Hey, I'm here for my painkiller. You can't do that. And some banks will let you do certain things, but some do.
In my experience, is a lot of banking institutions, they will not allow a power of attorney to be used, say, over 12 months old or 6 months old. And then all the financial brokers, your Merrill Lynch's, your Edward G. Jones, your Ameriprises, all those people, they want their own internal powers of attorney done. They won't accept regular powers of attorney. Still a very useful instrument.
It comes in a lot handy when the person's incapacitated and can't go. You can still go pay their water bill so the water not shut off. Those kind of things, or pay the mechanics. And there are some prescriptions you can pick up. You can call ahead to see whether they're going to honor the power of attorney, but it varies from business to business whether they're going to honor or they're not bound to.
A common question I get all the time in my law practice: if I grant my daughter a power of attorney, have I turned my life over to her? Am I just stuck with her for the rest of my life?
You can rescind the power of attorney too. Rescind is fancy word for take it back
and cancel it. So it's a voluntary grant. You're not handing over all of the management of your affairs and then never be able to retract it. You can cancel the power of attorney anytime you want to.
Right.
All right. How do you go about canceling it, by the way?
You file a form that says, "I'd like to cancel my." I really have no clue.
Right.
I've never canceled one before.
Well, you got to file it in the courthouse.
Oh, okay.
You got to file a cancellation and a renunciation, a cancellation of a power of attorney. It has to be filed. Otherwise, third parties can allow it. But the reason why it's going to be filed is that once it's filed in the public record, then everybody's deemed to have legal notice of it, even though they're completely unaware of it. So if you can file the notice of the cancellation.
Do you have to, the person with the power of attorney, do you have to give them notice?
Well, sure. I mean, it's a good thing to do so they can stop using it. but it doesn't render the cancellation any less effective. So powers of attorney, very useful. They're voluntary. They have to be specific as to form. Right, in Louisiana.
And another thing people do, they get a power of attorney, sign it, and then bring it to a notary.
Right.
What's wrong with that picture?
Got to sign it before a notary and two witnesses.
In the presence of a notary.
And two witnesses. Now, the two witnesses are sometimes needed, sometimes not. But if you remove all doubt, it's called authentic form in Louisiana. Just go ahead. Anything dealing with land has to be done before a notary and two witnesses. Anything, if you're going to have an act of donation, the power of attorney has to expressly say that the agent has the authority to execute acts of donation. If the agent is able to donate things to the agent, him or herself, then the power of attorney needs to expressly say that the agent has the authority to express things to him or herself. Hey, one more issue that comes up in my practice. You ever hear the term springing power of attorney? Oh, this might be for another episode. We're going to get into what some people say. Well, I really don't want my agent to have full authority. I only want to have the agent if I go senile, or if I lose my mental capacity, or if I go ill. I want it to be conditioned on a future event. That's called a springing power of attorney. It springs into effect only upon the existence of the condition. Good idea, bad idea.
Well, who determines whether you're senile or not?
Precisely why it's a bad idea. If you're going to trust someone to be your agent, let them be a full, unbridled, unlimited power of attorney. If you're going to try to put a condition on it, it gets really squirrely.
So it doesn't designate who's going to make that determination?
Well, it's usually two doctors. It's going to say two doctors will say, I don't have mental competency. So what's the problem with that? Can't find a doctor. The doctors don't like signing this stuff. They don't want to get involved. It really hinders the agent. Don't do it. Don't do a conditional power of attorney. Do full or carte blanche, unbridled power of attorney. Any other thoughts on power of attorney before we wrap up this episode?
So I think springing power of attorney is in my near future.
In what regard?
The whole senile, when I get senile, here's the power. But I've never heard of the springing power of attorney, but I thank you for sharing that information.
Don't think it's a good
Lastly,
it's there if you
just
want.
be aware
Not a good idea.
that even though it's titled power of attorney, you have no attorney powers.
No. You don't get to start practicing. It's just a common nomenclature, man. I'm making somebody my agent.
Agent, right, not your attorney.
It's like in biblical terminology, you're Pharaoh and you're designating Joseph to run things.
Right.
You're giving Joseph your reign to go carry out your wish.
Very good.
Talk about that.
I'm impressed.
Pharaoh Joseph.
Yeah.
Power of attorney. Well, we're going to Pharaoh and Joseph ourselves on out of this segment. For Jonathan the Law Dawg Fontenot, I'm Mark the Attorney Judson. Thanking you for tuning into this episode of Law Talk. Go to the bottom of the screen, send us your legal questions. Catch us on our next episode of Law Talk.